chapter on fundamental rights. Now I am going to talk about a very important aspect, that is, can fundamental rights be amended or amendability of fundamental rights. So the question is, can fundamental rights be amended? So, or amendability of fundamental rights. So this was a long standing question. It took many decades to settle the matter. So it's a bit a long story also. See, so we have to be very careful about this, very interesting, very important, exam point of view also very important, because many times this question has been asked, which ultimately led to the concept of basic structure of the Indian Constitution. So one thing we have to remember here is Article 13 says no pre-constitutional law, no law shall violate fundamental rights. So Article 13 says no law shall violate fundamental rights. So that is what is mentioned. So what is this law? This law, the understanding right from the beginning, the Nehruvian idea or the B.R. Ambedkar's idea, everybody, the Constituent Assembly knew that no ordinary law, the meaning was that no ordinary law shall violate fundamental rights. That was the meaning of it. But can there be an amendment to the fundamental rights? Yes, there can be, because the understanding right from the beginning was that Parliament has the power to amend any part of the Constitution, including fundamental rights, because Article 368, the amending power of the Parliament, Parliament can amend any part of the Constitution, including fundamental. That was the understanding of the Constituent Assembly. So based on that understanding, First Amendment Act was passed in 1951 itself to provide reservation for scheduled castes and scheduled tribes. So to provide that, Parliament amended Article 15 and Article 16. We added a clause to provide reservation for. So 15 and 16 talked about there shall be no discrimination, but now we are saying we can discriminate for the purpose of providing some benefits to the people. So 15 and 16 both are fundamental rights. So Article 15 and 16 were amended. So this amendment, the First Amendment Act, was challenged in the Supreme Court in the Shankari Prasad case. Shankari Prasad case, 1952. And the challenge was that, can these fundamental rights be amended? Or Article 13, the question raised was that Article 13 says no law can violate. So this constitutional amendment law cannot violate, cannot change fundamental right. Their argument was that. But Supreme Court made it very clear, Article 13 is only for ordinary law, and Supreme Court in the Shankari Prasad case in the first year, 1952 itself, Supreme Court made it clear that Parliament can amend fundamental rights by using Article 368. Fundamental rights can be amended. There should not be any discussion on this. That is what the Supreme Court said in the First Amendment Act itself. So the question was raised, can fundamental rights be amended? Supreme Court in the Shankari Prasad case declared that yes, Parliament can amend fundamental rights using Article 368. Article 13 is not a restriction on Parliament's amending power. Article 13 is not a restriction on Parliament's amending power. So that is very clear. Then this same question came up again and again in the Supreme Court. See, please remember, whenever there is a question mark on the interpretation of the Constitution is concerned, a Constitution bench is created. A Constitution bench. Constitution bench means the Chief Justice will constitute a Constitution bench in case of, or where there is a requirement of interpretation of the Constitution. So normally it is a 5-judge bench. Now, if the same question comes back, a higher number of judges will sit, always in odd numbers. So, next time when the same question comes, 7 judges came, 7 judges will sit. It will be a 7-judge bench. If the same question again a third time comes, it becomes 9 judges. So, the same question, can fundamental rights be amended? First it came in Shankari Prasad case, again it was asked, a third time it came in 1965, a third time the same question was raised in 1965 in the Sajjan Singh case. Sajjan Singh case, 9 judges sat and they also said the same thing, that yes, fundamental rights can be amended. So, this 9-judge bench also in 1965 Sajjan Singh case declared that yes, fundamental rights can be amended by using Article 368, and Article 13 is not a restriction. Parliament has the amending power. That is what declared even in 1965. But please remember, Supreme Court has a power, in the jurisdiction of the Supreme Court, I will be talking about that. Supreme Court has a power which is known as a revisory jurisdiction. It can revise its earlier verdict. Supreme Court has revisory jurisdiction. Supreme Court can revise. So, in 1967, in the Golaknath case, Supreme Court revised its earlier decision and declared that Parliament has no power to amend fundamental rights. In fact, in 1967, in the Golaknath case, it is a complete, reversal of role. It is a completely overturned its earlier position. See, please understand, see, judges are also, they behave according to the political executive. Please see, nowadays Supreme Court has suddenly become very passive. Why? Because of an all-powerful Prime Minister Modi is there, and the Supreme Court behavior has completely changed. You might have already seen in the, during the Corona time, and when the migrant laborers were walking, and the Supreme Court refused to even help them. And so much of criticism was there. Supreme Court became so passive. Why? Because of the presence of an all-powerful Prime Minister. Similarly, during Nehru's time, they were not afraid of Prime Minister Nehru, but definitely Nehru was a father figure. There is no question. But 1964, Prime Minister Nehru died. There is a political confusion. Judges, suddenly started talking a bit independently. In 1967, Supreme Court declared that the Parliament has no power to amend the fundamental rights. In fact, Supreme Court said that fundamental rights have a transcendental position. Transcendental position, a special position, elevated position, a transcendental position, and no authority including Parliament. Please note, it said, and no authority including Parliament, no authority including Parliament can amend or abridge the fundamental rights. Can amend or abridge the fundamental rights. Parliament, no authority including the Parliament can amend or abridge the fundamental rights. It also said the word law in Article 13 includes constitutional amendment law. The word law in Article 13 includes constitutional amendment law under Article 368. That means no law shall violate fundamental right includes any constitutional amendment also. So there is a totally new meaning to Article 13 given by these judges in 1967, and they also said if at all if fundamental rights are to be amended, a new constituent assembly should be created. If at all fundamental rights are to be amended, a new constituent assembly should be constituted. Constituent assembly should be constituted. A new constituent assembly should be. Parliament has no power. They even said, in fact, in this judgment, they even said Article 368 does not confer Parliament any power to amend the Constitution. It even said Article 368 does not confer any power to the Parliament to amend the Constitution. Because they said Article 368 talks about procedure to amend the Constitution. Because the heading of Article 368 is procedure to amend the Constitution. Nowhere it is mentioned it is Parliament's procedure. So it is a very weird and narrow interpretation, but Supreme Court said this. So whatever Supreme Court said till 1967, they overruled everything and said that Parliament has no power to amend fundamental rights. There is no amendability, and if at all you want to amend, especially constituted Constituent Assembly should be created. That is what it was mentioned in the Golaknath case. It was a total revolution, totally different verdict, and it was in the backdrop of the political vacuum or the instability in the country. 1965 war, India was almost, of course, with the Pakistan, 62 we got defeated, political executive was weak, then droughts were going on, economy was in trouble. Prime Minister Nehru died, Lal Bahadur Shastri died, then elections in 1962 election, then 67 election, Congress lost many of the states. There was no clarity. Indira Gandhi was about to, it is still in the process of getting in charge of the whole thing. So, judiciary struck. So, this judgment, see, whenever there is a judgment which is not to the liking of the Parliament or the executive, Parliament can always make a new law. Parliament can always amend and overrule the judgment. So, in 1971, 24th Amendment Act was passed. See, by this time, elections, once again election, 1971 election, Indira Gandhi got a massive victory. Garibi Hatao was the slogan, and she got a massive majority. When the Parliament was reconvened in 1971, say 24th Amendment Act was passed to overrule. So, what is the purpose? To overrule the Golaknath judgment. To overrule the Golaknath judgment. And in the process, 24th Amendment Act, two changes were made. One was Article 13(4) introduced. Article 13(4). One more article was added. So, 24th Amendment Act, Article 13(4) added, and it said that nothing in this article shall apply to any amendment of the Constitution under Article 368. It simply said nothing in this article shall apply to any amendment made by Article 368, meaning Article 13 says no law shall violate fundamental rights, but if a law is made under Article 368, it is not coming, because this no law was only for ordinary law, not for constitutional amendment law. That was our understanding till now. But in the Golaknath judgment, they changed and said that no, this Article 13 includes constitutional amendment law also. Now, 24th Amendment Act, a new article has been added to clarify and said that this law in Article 13 means only ordinary law. The law in Article 13 means only ordinary law. That is the meaning of the statement. Nothing in this article shall apply to any amendment made under Article 368. That means, those who could not understand this, that means Article 13 is applicable only to ordinary law. That is what they made it very clear in the 24th Amendment Act. Similarly, Article 368, the heading of Article 368 was changed and written that now earlier it was only procedure to amend the Constitution. Now Article 368 says, the new heading says the power of the Parliament. The power of the Parliament to amend the Constitution and hence its procedure. So, the heading of Article 368 was changed. In the Golaknath case, Supreme Court said that you have no right because Parliament has no power to amend this Constitution. Article 368 is talking only about procedure, whose procedure is not mentioned, but now it is clearly mentioned. This is the power of the Parliament to amend the Constitution. Now Article 368 says, the new heading says the power of the Parliament. The power of the Parliament to amend the Constitution and hence its procedure. So, the heading of Article 368 was changed. In the Golaknath case, Supreme Court said that you have no right because Parliament has no power to amend this Constitution. Article 368 is talking only about procedure, whose procedure is not mentioned, but now it is clearly mentioned. This is the power of the Parliament to amend the Constitution and hence its procedure. So, this 24th Amendment Act once again, so even if you did not follow everything what I said in this 24th Amendment Act, you please understand and remember only one thing. This 24th Amendment Act restored the power of the Parliament to amend any part of the Constitution. 24th Amendment Act restored the power of the Parliament to amend any part of the Constitution, including fundamental rights. So that is the meaning. One sentence. 24th Amendment Act 1971 once again restored. In Golaknath case, Supreme Court said that Parliament has no power to amend fundamental rights. 24th Amendment Act 1971 restored the power of the Parliament to amend any part of the Constitution, including fundamental rights. Now, this 24th Amendment Act was challenged in 1973 Keshavananda Bharati case. Keshavananda Bharati case. So, in the Keshavananda Bharati case, I mean it is a landmark judgment. We will be talking about that separately, but please remember only one thing. In this Keshavananda Bharati case, Supreme Court upheld, accepted 24th Amendment Act. Supreme Court said yes, 24th Amendment Act is right, there is no problem. That means Supreme Court reconfirmed the power of the Parliament to amend fundamental rights. But Supreme Court added a new dimension by saying that, but subject to basic structure of the Constitution. But subject to basic structure of the Constitution. So, the Parliament or the Supreme Court accepted the power of the Parliament to amend the Constitution, including fundamental rights, But Supreme Court said that, but subject to the basic structure of the Constitution, Supreme Court brought a new concept called basic structure here. I'll come to that. So that means Parliament has limited powers. Parliament has limited powers to amend the Constitution or amend the fundamental rights and the Constitution. That is what is mentioned in the Keshavan Bharati case. So it is a partial victory for the legislature, because 24th Amendment was upheld. They said 24th Amendment Act is valid, but Parliament's power to amend the fundamental rights and the Constitution is restricted, is limited, because it is subject to basic structure of the Constitution. So this was a victory. The power got restored, but still Parliament did not rest here. In 1976, 42nd Amendment Act, 42nd Amendment Act, and Parliament amended Article 368 once again and added 2 points. One, Parliament said there is no limitation on the Parliament in its amending powers. There is no limitation on the Parliament in its amending powers. So this means it clearly said that there is no basic structure. Then they also said in Article 360, one more article was added and said that there is no judicial review. There is no judicial review. So two things added: no limitation on the Parliament's power, so no basic structure, and no judicial review. So the power of the judiciary to review a constitutional amendment has been no judicial review for constitutional amendments. For constitutional amendments. So this is what the 1976 42nd Amendment Act did. But this was again challenged in the Supreme Court in 1978 Minerva Mills case. So this was once again challenged, 1978 Minerva Mills case. So in this again, it is a wider judgment, but in that, what is interesting for us is the Supreme Court declared the 42nd Amendment Act related to Article 368. That means no basic structure and no judicial review. That has been struck down. Supreme Court struck down both the amendments of Article 368 and declared that there is judicial review and there is basic structure. Supreme Court declared that there is judicial review, and they said that judicial review is a basic structure. There is judicial review and there is basic structure. So what Parliament said in 1976 through the 42nd Amendment Act, that there is no basic structure, there is no judicial review, Supreme Court once again said that yes, there is judicial review and there is basic structure. So naturally this would have next is in the turn of the Parliament. Now Supreme Court once again restored their judicial review and judicial basic structure. But subsequently, even though Indira Gandhi came back to power in 1980, about the Minerva Mills case, when I said, I mentioned 1978, but the verdict was in 1980. So when I wrote, of course, the case was there from that time, but final verdict came only in 1980. So Minerva Mills case 1980. So 42nd Amendment Act 1976, and that was questioned in the court, and finally the Minerva Mills judgment came in 1980. So please correct, when I mentioned I talked about 1978, that is not correct. The final judgment was in 1980. Subsequently, even though Indira Gandhi came back to power in 1980, she decided not to she was a changed personality altogether, decided not to confront the judiciary. So, I'll say they decided to stop this fighting. So, decided not to confront the judiciary. So, she accepted, or the parliament accepted the Minerva Mills judgment. That means, so what is the present status? So, the present status is the Minerva Mills judgment, and it is very clear. It says parliament can amend fundamental rights, parliament can amend fundamental rights, but subject to the basic structure of the constitution. That means parliament has amending power, parliament can amend any part of the constitution including fundamental rights, but subject to the basic. So, parliament has a limited power, parliament has limited power. It is not unlimited power. Parliament has limited power in amending the constitution, not the unlimited power. So, you see, till 1967, till Golaknath case, parliament had unlimited powers. In the Golaknath case, Supreme Court said that you have no power. In Keshwan Bharati case, Supreme Court once again accepted and said that yes, parliament has power to amend the constitution including fundamental rights, but you have only limited power. So, the basic structure concept came. So, since 1973, so what was said in the Keshwan Bharati judgment, that parliament has power but limited power subject to the basic structure, that is what has been upheld in the Minerva Mills case of 1978. So, parliament has amending power, parliament can amend fundamental rights. Article 13 is applicable only to ordinary law, not to constitutional amendment law. So, parliament can amend fundamental. So, that is the question has been finally settled. So, even today, even last year also, when the economic reservation was introduced, in article 15 and 16 were amended. So, parliament is amending, parliament can amend fundamental rights, but subject to the basic structure of the constitution. That is the meaning. There is no unlimited power, there is no uncontrolled power. They have power, but limited power to amend the constitution. So, that is the meaning, and that is the answer to the amendability of. So, many times this question has been asked, can fundamental